Good afternoon, my lord.
Hey, what is the problem? I say you should call the case. We have been on, we can't see you.
My lord, I'm sorry, my phone is bad. I'm trying to use your guidance laptop to connect.
Is it now that we'll be trying to connect? What is the time now?
My lord, we're waiting for the laptop. Open the course list. Open the course list. Just open the page. It's fast.
I think I should call the case myself, since the registrar is still not online. Suit number NICN/CA/46/2018 between Mr. Michael Usiabulu and one Cross River University of Technology Kurutex, 2 Governing Council Kurutex, 3 Vice Chancellor Kurutex. The case is for judgment. This is the judgment of the court. This suit was slated, the judgment on this matter was slated to be delivered on the 8th of June 2023. However, due to unforeseen circumstances, the case was adjourned today for judgment. By the amended statement, by paragraph 32 of the amended statement of facts, the claimants phrase for the following reliefs. They are: 1, a declaration that the purported deployment of claimant by sad dependent is incompetent and inconsistent with claimant's contract of service with first dependent and extant statute establishing the first dependent and therefore invalid, illegal, null and void, and of no effect whatsoever. B, a declaration that the sad dependent letter of May 7, 2018, which purportedly redeployed claimant to Bursary Department of the first dependent and directed him to report to the University Bursar, is incompetent, illegal, invalid, null and void, and of no effect whatsoever. C, an order of this honorable court directing the third dependent to reinstate the claimant forthwith to his original position in the first dependent as an academic staff in the Department of Accountancy with full academic rights and privileges, including payment of all his entitlement and benefit he would have earned for the purported deployment. D, an order of perpetual injunction restraining the third dependent from doing any act in order to put in effect his threat to frustrating claimant in completing his master's degree program, which he is currently pursuing in first dependent, to meet up with the deadline set for the second dependent, set by the second dependent. E, an order of perpetual injunction restraining the third dependent from further redeploying the claimant or purporting or putting into effect his purported redeployment. F, the sum of 100 million naira damages for wrongful redeployment and consequent harassment, intimidation, humiliation, emotional and mental torture, loss of worth and status, shame, hardship, embarrassment occasion thereby. G, the sum of 10,000 naira, 10 million naira as cost of this action. The defendants file its amended statement of defense. A list of witnesses. The claimant testified as CW1 and tendered exhibit which were admitted in evidence and marked as exhibit accordingly. I have reproduced the facts, the case of the claimant. I have also reproduced the case for the defendant in the body of the judgment. So counsel, I will keep reading those ones. The counsel for the defendant formulated 2 issues for determination, while counsel for the claimant formulated 3 issues for determination. All the issues have been captured in the body of the judgment, and the argument canvassed in respect thereof have also been reproduced in the body of the judgment. I shall now proceed to the decision of the court. I have carefully considered the processes filed in this suit, the evidence led by the parties, and oral and written submissions of counsel to both parties. The law has always been that a claim is circumscribed by the reliefs claimed, and the duty of the claimant is to plead such facts and materials as are necessary to sustain the reliefs and adduce evidence to prove same. This means that the issues in an action are ascertained and the reliefs granted based on the facts pleaded. In other words, it is the pleading that delineates and circumscribe the issues to be determined by the court upon consideration of the evidence adduced in support and the facts pleaded, in support of the facts pleaded. Consequently, the courts are prohibited from considering issues based on facts which have not been pleaded. Therefore, where any issue outside the pleading is introduced by the parties, they will go to no issue, and even if inadvertently admitted, will be discarded at the judgment stage. See the case of Atolagbe versus Sharon. See also Iwoha versus Naipost. See also Ayapulu versus Mecca. See also below that a court of law should not grant a party a relief which he has not claimed or asked for. This is based on the principle of law that a judge is not a Father Christmas and thus cannot grant a relief not sought. See the case of Agbi versus Ogbe. See also Salubi versus Kwariagu. See also Atibi versus Kabel Mater. Thus, in Attorney General of Abia State versus Attorney General of the Federation, the Supreme Court has this to say: it is elementary law that a court of law is confined to reliefs and reliefs of the plaintiff. It does not go outside the reliefs or reliefs to grant what the plaintiff does not ask for. A court of law can grant all the reliefs sought by the plaintiff. It cannot grant part of reliefs, but it cannot grant reliefs not sought by the plaintiff. In considering pleading of the parties before the court is enjoined to holistically look at the entire pleadings and also not in isolation. This means the whole and entire pleading should be construed wholly and all together in order to get to the intention of the pleader. No part of the pleading would be interpreted in isolation. This is particularly so as in the instant case where the relief sought as per statement of facts are not stated in isolation. Fault of the facts pleaded. Accordingly, the relief's claim cannot be read in isolation of the facts pleaded in support of the relief's claim. See Adesalu and others versus Akinde and others. See also NDIC versus BN Limited. See also Anambra State Sanitation Authority and another versus Equinen. The Supreme Court, as per Adeke in this case, has this to say: the claim of a litigant, either plaintiff or defendant, depend on the abatement in the pleadings. In our adversarial system of administration of justice, it is the entire pleading of the parties that are looked into to determine the plaintiff's case. The relief's claim vis-a-vis the jurisdiction of the court and the purpose they are deducible from the pleadings and ancillary issues. Therefore, in considering case of the claimant as put forward before the court, I shall be guided by the above enunciated principles of law. Looking at the reliefs as enumerated in paragraph 32 of the statement of claim, of the statement of facts, it is clear to me that the best two reliefs are the main reliefs or principal reliefs being sought by the claimant, while the relief C to F are ancillary reliefs dependent on the grant of the rehab, depending on grant of reliefs A and B. In reliefs A and B, the claimant is praying for declaration that the employment of the claimant is incompetent and inconsistent with the claim of the contract of service, and that the letter of employment dated 7th day of May 2018 is incompetent, illegal, invalid, null and void, and of no effect whatsoever. The facts being relied by the claimant in making his case before the court are as follows: that sometime in 2002, the Cross River State merged 3 institutions of higher learning to establish the best dependent in this case. The claimant, who was one of the part-time members of staff of the defunct institution, attended interview conducted by the best dependent for absorption into the services of the best dependent. At the end of the exercise, the claimant was absorbed and redesignated as assistant lecturer. See Exhibit A. The claimant was absorbed, redesignated as assistant lecturer. See Exhibit A. However, upon resumption of duty by the new Vice Chancellor of the university, another interview was conducted for absorption, and my name at the end, the claimant was reabsorbed and redesignated as assistant lecturer again for the second time. See Exhibit B. Following staff audit conducted by the best defendant, the claimant by the Exhibit C informed the claimant that he is being given 3 months within which to upgrade his qualification or apply for a deployment to other departments or organizations.
Are you not the one who is going to sign this one?
Okay, the proof I'm going to sign this.
It is
Yeah, I sent it.
a response to Exhibit 3. In response to Exhibit C, the defendants tendered the claimants also tendered Exhibit D, which is a response to the claimant's letter, wherein it was stated that the letter Exhibit C has been withdrawn from the dependent, from the claimant. Please, counsel should not be making noise. You should mute yourself. You should mute yourself, please. The reason given for the withdrawal was that the claimant's appointment with the first dependent was confirmed with effect from 24th day of January. Sorry. 3 months after confirmation, claimant's employment was again given. The claimant was again given two years grace within which to acquire a master's degree, failing which the claimant will be withdrawn. In furtherance of his case to comply with the directives contained in Exhibit G, the claimant enrolled into the master's degree of the first defendant in the Department of Accountancy. See Exhibit H1 to 2, HHJJ, and GG. Prior to the enrollment of the dependent with the first defendant, the claimant had enrolled with the Benin State University for his master's degree, but could not continue to conclusion due to stoppage of his salaries for 13 months. See Exhibit T, X1 to 2, Y, AABB, CC, and DD. The claimant, while studying for his master's, agreed with the first dependent to write a memo to the dean of faculty and to the third defendant, complaining about allocation memos. The head of the Department of Accountancy by the Exhibit L requested for the deployment of the claimant. The third defendant, without any hesitation, acceded to the request and posted the claimant to Bursary Department. The claimant, while studying for his master's degree, wrote 2 memos, one to the dean of his faculty and the other to the third claimant, complaining of allocation of courses to lecturers in the Department of Accountancy. Sorry, I have touched something that distorted my setting. As a result of Exhibit M, the claimant has written a series of letters requesting for reversal of his redeployment and payment of his salaries, but all fell on deaf ears. The dependents on their part have maintained that the redeployment of the claimant did not vitiate any law or rule or regulation. Rather, it was done because the claimant's employment was ab initio not in order. The claimant was also withdrawn from his master's degree program as he was not qualified for the post. It is apt and proper at this juncture to reproduce the content of Exhibit M, which it reads. I will start from the heading, Redeployment Bursary Department. Management has observed that you were employed in 2003 as an academic staff of the Department of Accountancy, Faculty of Management Sciences, with a third degree with a third class degree in accounting and ICANN. Professional qualification, as you are expected to possess a minimum of a good second class honors degree and any professional qualification in your choosing field. Regrettably, management observed that you have not cured the deficiency you are hereby deployed to bursary department where your professional qualification is relevant for services with immediate effect. You are by this note letter directed to report to the university bursar for necessary action. Congratulations in your new appointment. Signed, Professor A. Owen Eno, Vice Chancellor. It is clear that the content of the above exhibit quoted letter of redeployment, it is clear and unambiguous. It is clear from the content of the above quoted letter of redeployment that it is state law that in the interpretation and construction of documents before the courts are enjoined in other words, in constructing documents which include pleadings of the parties in case the entire document should be construed holistically and together. It is clear to me from Exhibit M that it is not the letter, the Exhibit M is not a letter of termination of appointment because it did not intend to end the employment relationship existing between the claimant and the respondent. What Exhibit M has done is to assign a new role to the claimant, a new place of work, and a new task to be performed by him. On the meaning of redeployment, it has been defined to mean the moving of an employee from one job role to another. The new job or role does not necessarily need to be similar to the original role. And for example, and the example can it is simply a change a change of work schedule, see https://www.davidsonmorris.com, access on 14th day of June 2023 at 7:30 a.m. Redeployment is done for various reasons, but the reason must be suitable, and there must be an alternative to the previous employment or previous schedule of duties. Where there is reasonable reason, an employee is free to reject. Where there are no reasonable reason, an employee is free to reject the schedule. Therefore, moving employee from one job or role to another cannot in any way be same as Therefore, moving employee from one job role to another cannot in any way be same as termination of appointment, which aims at ending it is the right of employer to force or transfer or redeploy an employee from one branch to another or from one schedule of duty to another. What is important is employee is retained in the employment of the employer, and what is important is employee is retained in the employment of the employer, and nor was he posted or deployed to totally different organization that is not within the current employer. In such a situation, it has to be with full consent of the employee. In Shell Petroleum Development Company Limited versus Uwaka, reported in 2001, 10 Nigerian Kilo Report Part 72, page 64, the court held that it is invidious for court to foist on an employer a person who should occupy a particular position. Recently, this court in Adesanya Adeyemi versus Joachim versus Union Registrars Limited has decided that generally it is for the employee to determine where is it. Generally, it is not for employee to determine where it is to work, where he is to work, and that transfer may be justified, but in appropriate cases, transfer may be unjustified, and the law frowns as such, especially where the said transfer or redeployment or posting is meant to be punitive or mala fide, as where he transferred. The transfer is a product of punishment. In Mbachu versus Anambra Rural Development Authority, the Supreme Court stated that an employer can, at his discretion, prune the schedule of duties of employee, and the employee cannot preclude the employer from doing so. In this case, the facts of in this case, the facts are very clear and straightforward and not much in dispute. The claimant in this case rejected his redeployment to Bursary Department of the first defendant. Therefore, the question that needs to be resolved is, was the rejection justifiable or unjustifiable? There is no disputing the fact that from the evidence made available to the court, the claimant is a third-class degree holder from University of Nigeria in Nsukka. The claimant was employed in 2003 by the first defendant as an assistant lecturer in the accountancy department, Ogoja campus. Having successfully undergone several stages of rigorous interviews as per the claimant exhibit A and B. However, by the exhibit C, the claimant was informed that his qualification fell short of that required for teaching in the university. The claimant by the exhibit D protested, and the letter of protest the claimant by the exhibit D protested, and the letter notifying him of his shortcoming was withdrawn from him. See exhibit C, D, and E. Another letter, exhibit G, was issued to the claimant giving him 2 years grace within which he is to comply with the qualification needed for him to continue with his teaching career. The claimant enrolled into master's degree program of the first defendant under the postgraduate school. However, while the claimant was doing his master's, he wrote 2 letters to his dean, to the dean of his faculty, and to the third defendant, complaining about allocation of lectures to lecturers in the Department of Accountancy. However, instead of investigating the allegation contained in the said exhibit, the defendant decided to prematurely end the life of the suit. The claimant protested his redeployment by a series of letters, but to no avail. The salary of the claimant was stopped, and he was withdrawn from the master's program on the ground that he was not qualified. The defendant took the action he took when again the claimant bank under the theory that the claimant appointment was ab initio invalid on account of them was invalid, as according to them it was done in breach of extant law, rules and regulation governing the employment. However, the defendant never referred this court to specific provisions of the law or staff handbook which recognize the claimant's employment. The employment also made no The defendant took the actions they took against the claimant, basking under the euphoria that the claimant's appointment was ab initio invalid, and according to them, it was done in breach of the extant rules or regulation. Surprisingly, however, the defendants never referred this court to any specific provisions of the law or that of the handbook against the claimant employment. The defendant also made heavy weather on the claimant not having master's degree, which according to them is what will qualify the claimant to teach in the university. I have perused the Cross River State University of Technology Law as amended and the staff handbook exhibit KK 1 to 93, which are the extant laws regulations governing the employments of the claimants. This means that in the absence of any rules or regulation which was violated in the recruitment of the claimant, the recruitment of the claimant is therefore valid and appropriately done in accordance with the extant rules existing as at the time of his employment, as there was no any breach that was shown to have taken place in the process of the recruitment. This finding on the submissions of the defendant to the effect that claimant appointment was ab initio null and void has the position held by the defendant and the submissions having not been based on any law or facts has to be discountenanced, and I hereby discountenance it. With this finding, we are now left with the consideration of the applicability of Exhibit KK 1 to 93 to the claimant's employment. With the coming into force of Exhibit KK in 2005, all employment however, the existing employment made prior to the coming into effect of staff handbook still remain subsist and valid. In the circumstances, the claimant's employment is legal, is valid, and it did not violate any provisions of the law or staff handbook. Therefore, the fact that the staff handbook XBKK 193 has no provisions for redeployment. However, that does not mean that the defendant have no powers. The posting or the deployment of the claimant to the bursary department was therefore made mala fide and in abuse of power. It was made to suppress the claimant from voicing out his views on the irregularities he noticed in the departments of accountancy, which he taught. It was made to suppress the claimants from voicing out his views on the irregularities notice in the Department of Accountancy, which he sought for correction, but the defendants turned against him. This is sheer wickedness, and it shall not be allowed to stand. This case is another example of classical case where abuse of power by persons that are least expected to indulge in such kind of abuse. The people who should be interested in molding the characters of youth, our leaders of tomorrow, to engage in this kind of shenanigan is very pathetic. The officers in charge of the affairs of the university who are entrusted with the day-to-day running affairs of the university should be dedicated and interested to honestly run the affairs of the institution with all their strength by ensuring the due processes are followed in all affairs of the institution, including recruitment or otherwise. They have a higher duty when it comes to the issue of recruitment of teachers, because that was why the institutions were established for imparting knowledge, that is, for imparting knowledge. Recruiting unqualified teachers to teach in such institution is disservice to the entire nation, which will have negative consequences of churning out half-baked graduates that cannot add value to the society but add to its voice. I shall say no more on this. It is clear to me from the facts and evidence before me that the redeployment of the claimant was motivated by his complaint, which he sought for correction to be made. But instead of investigating to find out the truth, the defendant decided to vent their anger on the claimant by redeploying him to the bursary department. As I found out earlier, the deployment is not the same thing with termination. It is not termination. It is a process whereby an employer will reassign work to his employee. And this is a right which is inherent in the dependent, where there are no express provision for that. In the law establishing the best dependent and the rules and regulations, there are no provisions for deployment. However, by implication, it is implied the dependent has every right to post, transfer, or redeploy its members of staff appropriately. However, such redeployment posting must not be made at the expense of the employee being redeployed, and it must be made honestly and reasonably, and not taking of vengeance, as in the case at hand. In view of all I have been saying above, the claimant has been able to establish that his redeployment was mala fide, and therefore this court cannot allow it to stand. It is hereby nullified.
God please.
The defendant, the claimants, redeployment having been found to be mala fide cannot stand. The claimant is still an employee of the defendant. For avoidance of doubt, the orders of the court are as follows. 1, the redeployment of the claimant as per Exhibit M having been made mala fide to embarrass, harass the claimant is hereby nullified. B, the defendants are hereby ordered to forthwith allow the claimant to continue with his employment in his position as an academic staff in the Department of Accountancy with all his rights and privileges attached to the appointment, including payment of all entitlement and benefit he would have earned but for his purported redeployment. The claimant relies heavily in the unreported decisions of this court, which is Exhibit B. I have gone through that case. That case is not on all fours with the present case. It is distinguishable in that case, the issue is transfer outside the employment of the employer. It was a redeployment to the core civil service, which the defendant in that case do not have power to do so. That's why the court nullified that termination of employment. However, in the case at hand, the issue is a redeployment which can be done as of right by the defendant. But in exercising that right, it has to be done honestly and must not be done mala fide. Where the court finds out that it was done mala fide, the court has power to nullify it as it has done in this case. An order is also hereby granted restraining the third defendant from doing any acts in order to put into effect his threats of frustrating the claimant in completing his master's program with the first defendant. The letter of withdrawal of claimant having been made without any basis and without showing to the court what made such withdrawal to be valid is also nullifies. The claimant is hereby reinstated to continue his studies from where he stopped. Having ordered that the claimant is still in service and having ordered payment of entitlement to be made, the claimant is not entitled to the relief of 100 million naira being claimed as damages. That relief fails and same is hereby dismissed. I hereby award cost of 500,000 naira against the defendant payable to the claimant. The defendant are hereby ordered to pay the claimant 500,000 naira cost of this suit. This
Is a court business.
Is a court business.
yes,
Yes, my lord. May I announce my belated appearance?
Sorry, we have not taken appearance. We have not taken appearances at all. Sorry, sir.
Okay, okay.
My lord, may I humbly announce my appearance for the claimant?
yes.
My lord, my name is A.O. Okivame. My lord,
A.O. Okivame.
Yes, sir. O.K.
Yes.
H.I.
Yes.
B.H.
Yes.
A.M.
Yes.
E.N.
Yes.
My lord, A.O. Okivame, sir. My lord, I humbly appear for the claimant. Yes. My lord, we are very grateful for the orders of this court. Thank you, my lord.
Appearance.
Yes, appearance for the defendant.
Yes.
P.O. Upla. Philip Honor Upla. Yes,
Ufla for
Philip.
the defendant.
Yes, UPLA, my lord, for the defendant.
Yes. Thank you very much, counsel.
Thank you, my lord. We are very
Judgment
grateful.
is entered accordingly.
As the court pleases. Thank you, my lord.
I'm very sorry for coming late.
You are welcome.
Good afternoon, my lord.
Yes. Call the next case.
Yes, my lord. Suit number NICN CA 177-2013 between Mr. Efanga E. Okon.
Present.
Come and stand yesterday.
Yes.
And one, Ebrutu, Nigeria Limited. Two, Mrs. Henrietta Bassi, Henshaw. My lord, the claimant is present.
Appearance.
Humbly, my lord.
Yes.
E.B. Boko.
E.B. Boko.
Yes, my lord. My humble
Appearance for who?
for the
Appearing
claimant. For the claimant, my lord.
Yes. Any other appearance? Any
No, my
other
lord.
appearance?
No, my lord.
Yes.
The matter is for adoption of final written address.
Have you filed your address?
Yes, my lord.
Have you submitted on the other party?
No, my lord.
My lord,
Why?
they just filed.
We just filed it now. This morning. It was filed this morning.
You can't take it now since you have no submit. You have to take a date for adoption. Registrar, give me dates.
The defendant, they were supposed to serve us. The defendant was supposed to serve us with the amended final written address.
They have not submit.
No, my lord. That is why we had to file hers.
It's all right. When you serve them, maybe you will wake them up from their slumber.
Okay, sir. As the court pleases.
This case is adjourned. Give me date.
My lord, October 19.
This case is adjourned to 19th of October 2023 for adoption of final written addresses.
As the court pleases. Thank you, my lord.
Call the next case.
Suit number NICN CA 52-2019 between one, Mr. Sylvester Oga, two, Nkasi Ebo Ofem, three, Joseph Tony Atabi, four, Angela Rowan Otu, five, Cletus Adama Abang, six, Ibi Mboto, seven, Terim Ayame.
Present.
Present.
Okay.
6 and 7 are present.
Edra. 9, Dominic Ebiala Ode. 10, Gabriel Ubong Onake. 11, Udenye Omaji.
My lord, I am present in court.
12, Endurance Ipang.
Present in court, my lord.
13, Michael Ebam Kekun. 14, Nkedilim Basi Agbo. 15, Joy Basi Ekpeme. 6, Alem Okwaye. My lord, the seventh
Three
claimant
is present, please. 3 is present.
Joseph Tony.
Yes, apologies.
My lord, the third claimant is present. 7, 11.
Yes.
Boto is present, my lord. I had earlier announced. Sorry, my apologies, please. Ibi Mboto present, please. Sorry, I'm trying to turn on my video. I'm having a bit of a challenge, my lord.
Which number is he?
My lord is number 6 on the list.
Okay.
Number 3 is present. 6 is present. 7 is present. 10 is present, 11 is present, 12 is present. Others
Yes.
are absent, my lord. And Cross River State Government, 2, Attorney General, Cross River State, 3, Cross River State Civil Service Commission. My lord, the defendants are all absent.
Appearance.
With the greatest respect, my lord.
Yes.
I Mboto. My appearance is for the entire claimant, my lord.
Yes.
With due respect,
yes.
my lord.
Yes.
With due respect, my lord.
My lord, may
Yes.
I apologize for, sorry, please, counsel. May I apologize for the remaining different claimants who are not here. Most of them are having challenges with their
It's all right.
network.
You are welcome.
Following the location.
It's okay. Okay, counsel, you can go ahead with your appearance.
With due respect, my lord. Ama,
Yes.
Deputy Director, Civil Litigation, Ministry of Justice, Cross River State.
Yes.
My lord, my appearance is for all the defendants.
Okay. Yes. Umbotu.
Yes, my lord. Today's business is for adoption of consent terms.
Have you concluded? Have you signed?
Yes, my lord. Everything is concluded and signed.
When was the consent signed?
It was filed on the 26th of May 2023, my lord.
Yes.
Yes, my lord.
Yes, you can go ahead.
Yes, my lord. The consent term haven't been filed since 26th of May 2023 by the parties. We are adopting same to form the consent judgment of this honorable court, my lord. We so urge my lord to hold. Thank you, my lord.
Yes, Ama Epo.
Yes, my lord. My lord, the terms of settlement was filed, dated and filed on the 26th day of May 2023.
Yes.
My lord, we adopt the terms of settlement.
Yes.
And urge my lord to enter judgment accordingly. Let's see what's going on.
Yes, this is the order of the court. Having listened attentively to submissions of counsel for both parties, adopting the terms of settlement executed by the parties in the presence of their counsel as their consent, as their settlement for all the dispute in this case. The said terms of settlement are hereby entered Sorry, counsel. I was writing my ruling when the service went off. This is the order of the court. After listening to submissions of counsel adopting the terms of settlement filed on the 26th day of May 2023, it is the said term of settlement executed by the parties and their counsel is hereby entered as judgment of this court. The terms of settlement are hereby incorporated as forming part and parcel of the record of the court. The consent judgment takes immediate effect. It is like every other judgment of this court, liable to execution in case of any default. The judgment is entered accordingly.
As a court, please.
Thank you, counsel.
Thank you, my lord.
You are welcome.
We are very grateful, my lord.
You are welcome.
And I must thank the state for cooperating this time, my lord, meeting their demand.
If I am surprised.
We will continue like that, my lord.
Yes, amen.
Thank you, my lord.
Okay, you're welcome. I hope you will do in other cases.
No,
Mama,
my lord will try.
Huh?
My lord will try.
Okay, thank you. You are welcome.
Thank you, my lord.
Okay, have a nice
lord,
day.
we are grateful.
Okay, bye.
And you too, my
Bye,
lord.
man.
Bye, my
Okay.
lord.
Registrar, any other matter?
No, my lord, that's all for today.
Okay, thank you. The administrator, you can end the sitting.
It's all right, my lord.
Okay.